Hello and welcome everyone to another episode of The Agenda. Today we will be discussing the confirmation of Judge Amy Coney Barrett to the Supreme Court of the United States of America. Right. We're trying to move towards a different format for our discussion today, right? Where we look at first the very basics and the background of the issue that we will be discussing, right? Because to many people in our audience, specifically those who are law students or students of political science or related fields in India, who are not very well versed with either the law of the United States or the political science, or for that matter, the prevalent sort of contemporary political issues there. We'll be going over the basics of these issues, right? Whether it's the question of the Supreme Court confirmations or the particular nomination of Judge Barrett, now Justice Barrett, and the recent developments surrounding the confirmation, the hearing process in the Senate, as well as pending litigation in the Supreme Court. Right. So we'll be introducing the very basics along with the background of the issue, and then one after the other we'll be getting in. Some of the panelists will be discussing specific areas within both the legal process as well as the political landscape of the United States, and specifically the current sort of prevalent political issues. Also keeping in mind that the presidential elections and the other electoral races are just about a week away in the United States. Right. So just to give a brief background to our viewers here and to those who aren't well versed with the issue, just this morning, the Senate confirmed the nomination of Judge Barrett, who was very recently, 3 years ago, appointed as a circuit judge, or as a judge of the appellate system. Now, for those who aren't aware, the United States system works in a manner where you have district courts, then you obviously have the state judiciary, right? Following which, after the Supreme Court, just a second. Okay, there seems to be some problem with the video, I'm told. So we'll try to correct that first. We'll try to sort of restart this process because there seems to be some trouble with this. Okay. Let's hope that the audio and the video aren't a trouble anymore. And we've been facing some glitches here. Yes. Getting back to the judicial system for the United States. So you have appellate or circuit level benches which cover various states under them in the appeals process. Right? And above that, obviously, you do have the Supreme Court of the United States, but not every matter goes to the Supreme Court of the United States. Right? It's very few matters every year. The term begins in the beginning of October, which just began at the beginning of the month, and goes on till the summer of the next year. And in that process, there's sort of even less than about 100 odd cases that are taken up, at times even about 40, 50 above that, but just about 100, 150 cases are taken by the Supreme Court every year on questions of law, which are yet to be sort of propounded upon. And in that process, it's very different from at least the Indian system, which under 136 can take appeals from, can grant special leaves under the Indian constitutional framework. Supreme Court can listen to such matters. Right? In this process, the Supreme Court of the United States also has lifelong appointments. That the Constitution specifically states that there is, well, judges will hold office in good behavior, right? Which means that for as long as they are mentally and physically capable of performing the job, at the same time they aren't impeached and removed from office. Good behavior also would mean sort of there's no sort of impropriety in terms of the conduct. That's the other element apart from physical and mental control. I believe. Okay. I've been told that the audio and the video are not producing any issue at this point, so hopefully we'll just continue with this. Getting back to the United States system, right? So you have lifelong appointments of judges, and the constitutional sort of word there is in good behavior. And there are 9 judges currently in the system, has largely stayed the same for the last, I believe, 150 odd years. Again, I'm not sort of pinpointing on the specific date, but largely the system of sort of 9 judges has remained the same. Sure, there have been sort of threats of sort of packing the court, something that which we will be discussing today as well. At the same time, there have been, just like many other nations, there have been sort of threats to the independence of the American judiciary as well, specifically the SCOTUS. The specific tenure of FDR and the debates between, or debates regarding the New Deal, the economic program of President Roosevelt's policies come to mind. Obviously, we'll be sort of getting into the questions of court packing, but ultimately, how are judges appointed to the Supreme Court? Right? That's the sort of background here. The first part is that, again, there are 9 judges. Right? The Congress has decided that through the Judiciary Act. Right? The Congress here means the 2 houses within Congress, that's the Senate and the House of Representatives. And once the judges are appointed, post that point, you have sort of the 9 judges who sort of sit at the Supreme Court. Either a judge retires or a judge passes away. Right? That is in only these circumstances, or obviously so they're removed from office otherwise, but they're not sort of capable of sort of performing the job. That's how they can. There can be a vacancy in the Supreme Court. The most recent vacancy arose as a result of the passing away of Justice Ruth Bader Ginsburg, right, who was the second ever woman to be appointed to the Supreme Court. This was by, she was nominated by President Bill Clinton and served since then till the end of September when she passed away. After her funeral, President Trump nominated Judge Barrett, who was for this on the 7th Circuit. I believe it was 7th or 3rd, pardon me, on the exact circuit that she did come from. Again, we will sort of have a discussion on this and a past track record as well. I believe it was the 3rd Circuit. And then the confirmation process started. Right? So first, the nomination will go to the Senate. Senate sends it to a committee. The committee has pretty much a representative structure as the rest of the Senate, where you have about 12 people who are Republicans who constitute the majority in the Senate currently, and 10 people from the Democrat, or 10 senators from the Democrat side. But ultimately, sort of a process of a few days, questions are asked, and you effectively have what are called hearings, where senators ask questions to the judge or any political appointee. And because the process is, because the constitutional requirement is that the judge has to be confirmed by the Senate. Right? So what is the appointment procedure? That the judges have to be nominated by the president and confirmed by the Senate. So there are 2 sort of requirements when it comes to appointment of judges to the Supreme Court. That is the distinction between the judge and the justice. So this morning, Indian time, or sort of last night American time, the way you look at it, Judge Barrett became Justice Barrett, right? And she took oath. She was administered the oath by Justice Clarence Thomas, right? Who was appointed quite a while back actually, who's currently the second senior most, assuming that you have the the Chief Justice of the Supreme Court as the senior most judge in that regard, in terms of experience or sort of longevity of tenure. He's the oldest or the senior most in that regard, right? If you go by age, Justice Breyer is obviously older. But yes, he administered the oath to Judge Barrett, who became Justice Barrett earlier in the morning, if you go by Indian time. And that's largely what we will be discussing. Okay, I believe there's still some trouble with video in the glitch. Right? We're not going to try to do much about it, right? As long as we can sort of get a sort of coherent and sort of continuous video. I think let's sort of aim for that. We'll try to make any edits and amends at the end once we can sort of end up uploading the video, right? So I'll first be joined in by Mr. Siddharth Kumar, right? And but before I sort of bring him on, what all we'll be discussing, like I said, we'll be discussing the legal, the political process, right? Both aspects. We'll be discussing the past record of Justice Barrett, right? Some of her key judgments, her track record, her previous experience. She's been a professor of law at Notre Dame, from where she completed her law. She was a law clerk with Justice Scalia. And we look at the sort of political process, how the Senate reacted, how the Senate has reacted, right? What was the political divide? Why was the political divide? What happened in the hearings? What are the sort of key questions that were asked? What was the nature of the hearings? And post that, we'll also sort of look at the pending litigation before the Supreme Court right now. Right? Like I said, there's a very limited number of cases. Some of them turn out to be sort of politically in question because ultimately, almost all questions of constitutional law at some stage will have a political consequence, right? Even if they're not decided as political matters, they will have a political impact, right? And obviously, there are sort of other considerations, whether of ideology or whether of sort of political aspects, considering there also is an election coming up and people sort of look forward to, let's say, a judge of a certain judicial philosophy to be appointed to the Supreme Court. So we look at those aspects. Some of the key cases that people sort of fear will either be overturned or some particular rights will be impacted, and what is the law regarding all of those aspects. And if we do have time at the end of it, we'll try to sort of also look at, if at all, right, depending on how the conversation is going, and if our audience is really interested in this, we can look at sort of drawing Indian parallels with the Indian system, what can work here, what can't work here. Sure, our intention here absolutely is not to say, okay, how is this going to impact India, right, in terms of how the legal philosophy of India is going to change. That's not going to happen, right? Let's just sort of make it abundantly clear right at the beginning that's not our intention, right? Even if we have certain commonalities, even if the Indian system has certain commonalities with the American system, it has to do with the fact that we follow a system of sort of the common law, which has sort of judge-made precedential value, and it's sort of in that sense even closer to the British system, right, or the sort of British English common law system that we're sort of still closer to than the American system itself. So we're not necessarily looking at this issue as something that we as Indians are going to sort of learn something from, or how it's going to impact us, or if Judge Barrett's particular judgment is going to sort of impact Indian jurisprudence in any regard. No, that's not our intention. Right? This is very specifically about the United States of America, right? It's about the law, it's about the politics, it's about the processes, right? That's what we will be discussing. And obviously, there's ideological, political considerations apart from the law. We try to touch a bit on all of those. We try to look at the litigation that is pending before SCOTUS right now. And obviously, like I said, the process within the hearings, what all happened, we will comment on those things as well. Right? We're planning a few podcasts in the coming weeks around many developments in the United States, right? Whether it's the antitrust case that the Department of Justice is bringing against Google or Alphabet, or it's the coverage for the presidential elections, or it's sort of other aspects regarding the United States. Our plan at least is to discuss some of these in the coming weeks. And in that regard, we would be looking forward to comments and suggestions and recommendations and questions from your side. So feel free to sort of write to us and comment and sort of send us your messages regarding any recommendations and suggestions that you might have in that regard. Right. So I think I've given a brief idea as to what all we will be discussing. I've given you a brief idea about what all the procedure is about. So after the hearings are complete, in this case, the hearings were completed. 12 votes were cast by the Republican side, and the 10 Democrats were not present. And ultimately, that the committee sent it back to the Senate, which early this morning, in terms of IST, confirmed, and Justice Barrett or Judge Barrett took oath as Justice Barrett thereafter. So that's pretty much the background that is necessary here. The rest we'll sort of see flowing in our conversation. So now I'd like all of you to sort of join me in welcoming Mr. Siddharth Kumar.
Hi, Ajay.
Welcome to that.
Yeah, I think everything's working. Yeah, that's fine.
Great. Yeah, that's always a concern that the audio and the video is all right. Okay. So, Siddharth, let's go over your initial comments, your, if at all we can call them sort of opening statements, your initial comments on sort of the considerations regarding sort of sending Judge Barrett to the Supreme Court, or judicial philosophy, if you want to sort of talk about originalism or textualism, and then we'll sort of get into her past track record. We can look at some of the specific cases, and we can sort of discuss, okay, there's a certain judicial philosophy that you're sort of applying there. Right? So some initial comments in that regard.
Well, starting with, I wouldn't want to filibuster, but that perhaps has been the issue here as well. The changes with the filibuster and the norms for the Senate to confirm the justice to the Supreme Court have really played a key role here. I mean, substantively, there wasn't much to say other than some moral pictures that were drawn that, following the Thurmond rule, you don't want to appoint a justice in the final year, in the election year. But as you and a lot of people said, a president isn't appointed for 3.5 years and isn't appointed, just for your convenience to raise issues out, that you can't appoint now because you're going to be elected. You have a right and a duty under the Constitution to appoint, and you should appoint. So that was perhaps something that I didn't. It was just a sham facade in a way. The most consistent thing about American politics has been its brutal. Can you hear me, Ajay?
Yeah, I'm just getting him to also check that on the video and the audio. Listen, I can hear you absolutely.
Okay, great.
Getting it
right. So I mean, most consistent thing about American politics has been the brutal partisanship, and this time wasn't different, right? This time as well, the House Democrats were again on the same tune that how can you appoint someone who's going to give a textualist interpretation, the same Roe v. Wade argument. Are you going to repeal Roe v. Wade, which has frankly just become the it's the whole Wile E. Coyote and the Roadrunner story. So every time the Roe v. Wade is the Roadrunner, every time Wile E. Coyote comes with a TNT, and it becomes a matter of appointments and so on and so forth.
Yeah, absolutely. Right. So I think that's a very important point that you bring up. Sorry, let's have you finish and then I'll sort of get my
right. I mean, as she became Justice Barrett today, we really just saw that the procedure was set up. The idea was set up right after Ruth Bader Ginsburg died. The track was set. It is perhaps not accepting this that was going to happen. Let's be honest, it was going to end up here only. The resistance was going to, Democrats were not going to take it very lightly. So, but it did culminate in a very, very interesting hearing in the Senate. and really did exemplify how good of a judge. Just forgetting about the ideas and principles that she might have, but a good judge and a learned judge, as we say here, that Amy Barrett should be.
Yeah. Okay, so again, I want to first pick up on the learned part here, right? Before we sort of get into the sort of ideological or judicial philosophies clashing, right? A brief background, if you'd also, I think it'd be great if you could sort of give for a viewer. Right? She's been a professor of law, someone who got support from both sides of the political line, right? The political divide. When she was confirmed as a circuit judge, right, has had support from both sides of the political spectrum in the United States as a professor of law. Right. So for our viewers, she was a professor of law at the university where she studied, at Notre Dame. And she taught civil procedure, she taught constitutional law, and she taught principles of statutory interpretation. Right. I'm guessing it's just called statutory interpretation there, and we add principles. But yeah, the idea here is that she taught these courses. She had a good track record as a student. She was well published, and post that she had support from students who were both, let's say, Democrats or Republicans or liberals and conservatives. So that part was sort of there, up until the point that she was nominated by President Trump to the Supreme Court. Because if you look at her record as, what was the voting record before her when she was appointed to the circuit bench? There's a stark difference between the voting record for appointment to the circuit bench as opposed to the current the vote this morning, right?
Right.
Again, it's pretty much the same. Sure, there must have been a few changes in the midterms and all, but it's pretty much the same Senate, and it's the same judge. Right? It's not like the judicial philosophy sort of become extreme in the last 2, 3 odd years. But we see extreme sort of difference in terms of the vote. Right, within the Senate. Right. So again, I think something that I sort of borrow from you here is the professional competence, irrespective of ideology, that right. So as a legal scholar, she is undoubtedly sort of proven herself. There's no sort of question about that. Another question that arises a lot in this, right, and I think it's a very interesting sort of element here. I'd like you to sort of come in on this, and then we sort of move to the more sort of ideological, sort of political battles. Is the people say, or at least in the initial periods right after the nomination by President Trump, some were suggesting that she doesn't have adequate experience on the circuit bench. Now, for our viewers here, obviously there's a political consideration, a strategic consideration, if I may, not a political one in that sense. Strategic in the sense that a president would want to appoint a judge who's obviously experienced considerably, but also young enough to occupy the office long enough.
Right.
So in that regard, both Justices Kavanaugh and Justice Gorsuch before him, right, both of them were sort of relatively young. I think she's younger than the both of them, but and I think Kavanaugh is also older amongst the 3 Trump appointees. But the idea is that even if they're sort of below the 50 age mark, they would sort of, same goes with sort of Justice Roberts when President Bush appointed him. I think he's very, very young at the time. And same goes with Justice Kagan, Justice Sotomayor. Now, the interesting part is that Mary says she didn't have enough expertise or enough experience, if I may, on the bench. Whereas we see the Obama appointments, which in fact were of people who had never been judges before. Now, while we say that, okay, there is no requirement for one to be a judge or a lawyer to become a justice of the Supreme Court, the general norm custom has been that one is at least a lawyer, if not a judge. And we see the Obama years that if you look at sort of Sotomayor, right, she was Solicitor General before she was appointed to the Supreme Court. So that question of sort of experience certainly there's ample sort of precedent to suggest that one doesn't have to be a judge for, let's say, X number of years in that regard. Any comments on that, Siddharth? Anything? Do you think that's ultimately just it's just political bickering of some sort?
Well, I have a two-pronged comment on this. One, I
Yes.
think it's hardly. I mean, for us, we have this thing in our Supreme Court, Article 124, right? That distinguished jurist can be appointed to the Supreme Court. We've
Yes.
not had any distinguished jurists through, a number of reasons.
Yes.
We've not had
Yes.
one on the bench, but it is certain that just judicial experience is not the difference maker. And if we look at it from another perspective, I think it was Mitch McConnell Mitch McConnell who said that she's the common man's justice. She's not from Howard. She's not from Oxford. She's from Notre Dame. She served throughout her life, created a wonderful record in that period, and then went on to the bench with 2 years of experience. And she has authored around 110 opinions in the Seventh Circuit in the same period. So to say that experience is not there at all, when I might add that Chief Justice John Marshall was not a judge at all before his appointment, right?
Yeah.
And he was,
absolutely,
for all purposes, constitutionally, the best Chief Justice in the history of the Supreme Court. I think that's not debated at all.
Yeah, that's true. That's true. I think that's a very pertinent point. Sure, on some level, you had the emergence of the Republic back then. Right? It was a very young Republic, a fine experiment, if we may, or at least back in the day, that the United States was. But I think, yes, absolutely, that's a very pertinent point that 3 years on the bench, again, she has had adequate experience in that regard. If we sort of go with a comparative analysis of the judges that have preceded her. Right now, getting to I think is again the Indian point that okay, you have the question of the eminent jurist, and when we get to perhaps discussions about sort of comparisons with Indian systems and appointments, we'll definitely sort of get on that as well. I am quite inclined towards that direction. But let's get to the meat of it, right? You mentioned also Mitch McConnell, right? Whose sort of comments and track record in this has been very for the lack of a better phrase, ruthless. Right? And that sort of begins with the confirmation proceedings with Bork, right? With Judge Bork.
Right.
And for our viewers, again, this was a judge who was sort of nominated. I'm not getting the exact year, but this is. I believe back in the 80s, right? This is the early 80s. So that you can correct me if I'm wrong, yeah?
Yeah, I think it was around that only, and I think Reagan was the one who recommended him.
Yes.
Nominated him.
Yes, absolutely. So it's President Reagan who nominated, and then you saw a process within the Senate confirmation hearings, at least that period, that ultimately. Like his nomination was shot down, and ever since it's the phrase "bork" has become a verb.
Getting borked,
or a certain nomination has been borked. The idea being that okay, you've received that nomination, but it hasn't been confirmed, which is the angle when it comes to, let's say, the political. That's the first political fight in that sense. That okay, right. The president can nominate you. If you have, let's say, a president of your ideology, your party, then the next stage has to be that you have to have the Senate, the upper house, which is the other confirming body, which at that point was not a test that Judge Bork could meet. Right. Just a tiny factoid for our viewers here, for those of you, and because there are a lot of you who are interested in competition law and law and economics. A fine treatise on competition policy in the United States, and largely the philosophy behind antitrust issues, was by Judge Bork. It was called The Antitrust Paradox. It's not in print, and only second-hand copies are available, but they're saying that the Bork Foundation is sort of getting its act together, and perhaps by next year we will perhaps get new editions being churned out, right? Just a random factoid for viewers there, right? Yeah, but getting back to the sort of political battle there, right? So you had Mitch McConnell, who's this young senator back in the day, who saw this sort of just going out of the hands of the Republicans, and a fine judge and someone who could have been a fine justice at the Supreme Court was sort of done away with, right? His nomination was, for the lack of a better phrase now, balked. Right? Then obviously you saw the confirmation process to Justice Thomas, and thereon, I think very recently, there were a lot of political clashes when it came to the question of confirmation for now Justice Kavanaugh. Well, while there was a reaction from the side of even the Republican senators in terms of, okay, perhaps getting him to sort of step down, not sort of going ahead with the confirmation for now Justice Kavanaugh, on some level, what we saw was that in all of these confirmations, then Mitch McConnell, for our viewers again, who's the leader of the majority in the Senate for the Republican Party, was in that sense very ruthless. He said, it doesn't matter to me, right? These are political tricks, and I'm going to get this nomination through because I've seen what you guys have done with Bork, and these are just different ways of the same sort of strategy. Because, and this is the question that I want to sort of get to, Siddharth. If we look at the voting records of the Senate since Bork and since Justice Scalia and Justice Ginsburg, we see a very stark difference.
Right.
This is something that Lindsey Graham, who is the chairman of the Justice Committee, the Judiciary Committee in the Senate, pardon me, also said this, right, when Kavanaugh's hearings were happening 2 years back. He said that you go and ask Kagan and Sotomayor that they were good people, right? Just because we have political differences does not mean we went ahead and say, listen, these guys are evil people and bad people and we can't send them to the bench. Right? Sure, in the sort of in the second term's first part, that's the fifth and the sixth years of the Obama presidency, the Democrats still had control of the Senate. But you still saw a good chunk of Republicans voting to confirm these nominations.
Right.
And this is the track record difference we've seen since Ginsburg and since Scalia, that the Republican nominations have gone through much, much sort of narrower margins, where the Democratic nominations have received the assent or the larger sort of approval of other Republican senators as well. Would you like to sort of make any comments regarding this, apart from perhaps, let's say, Justice Roberts, who still had some amount of sort of support from a few Democrats during his confirmation? We've seen that the recent Republican nominations have been all very, very sort of tightly contested. It's gone down to the wire most of the time. Right. Especially these last three nominations, hands down.
I think when the Bork debacle happened, after that we've had two other instances where the resolve for Republican nominees and the debacles with them have been reiterated. You had the Clarence Thomas issue, you had the Brett Kavanaugh issue, and the same thing you don't see repeated when it comes to Democratic nominations, right? I'm not talking about the merits of the issue. That's not my question, actually, or even my assertion that there's what happened there. I'm not commenting on that. More of a comment there is, to your point, that Republican nominations are always more contentious. They're always on the fact that people's liberties are going to be questioned. Invariably, they're part from society, right? Like the Federalist Society from college. Then they've had some conservative views, and the same idea of Roe versus Wade, the same idea of the Healthcare Act, the same idea of your Second Amendment. It goes through and through and through. Considering also the fact that a judge, as much as they're conservative, end of the day would have to give a judgment according to the Constitution itself.
Yeah.
And anyways, they can't represent, show you a view right then and there. They can't do that. That's against judicial discipline.
Yeah.
But they're always far and out more contested, almost always. And this time I was surprised that this didn't go that route, because last time was particularly harsh. And at the end of the day, I remember that a Republican senator brought out this one thing that really did concern me about this Professor Kendi,
Yes.
proponent of the critical race theory and so on. And he said that Amy Barrett is a white colonizer because she adopted her children from Haiti. So that's one direction I really didn't want this to go to. And I'm glad that it did. But you're right. These are very, very, very contentious. And you see on the other side that isn't reciprocated.
Absolutely. Again, I think we're also getting in. I think Yash is also trying to enter, so maybe we'll also sort of have him join soon. But I think on that point, right? Ultimately, the clash therein, where you said that healthcare came in, right? Where sort of issues of Roe versus Wade came in. Right? I will get to the healthcare aspect and the Obamacare or the Affordable Care Act aspect of it, right?
Right.
We will get you to sort of present a very brief background of the law and the larger insurance policy therein, and then we'll get to what is the current status or what is the litigation pending before SCOTUS in that regard.
Right.
But before getting to that, right, getting to Roe versus Wade, it's a controversial issue, right? I'm just also trying to get in Yash. Right? So again, Yash, if you're sort of out there, do feel free to join in. We've sort of made the procedure available, right, for you to join in. Yes. Now, getting to Roe versus Wade here, ultimately, the larger clash arises as to whether, let's look at it as a legal issue first, right? And I think the larger clash is not between, and this is my understanding of it, right? And people can have different views on this. I'm not on the policy merits. I'm saying the larger clash is between a judicial philosophy versus another judicial philosophy, as opposed to where people genuinely stand on abortion.
Right.
Right? The question ultimately is, can the Supreme Court legislate? Right? That's the age-old question.
Right.
Can the Supreme Court create a right which does not exist in the Constitution? Right. My limited understanding of Roe versus Wade has been that, and correct me if I'm wrong here, is that it was pertaining to the rights of states. Now, as per the American constitutional framework, the very limited aspects that the federal government or the federal Congress can pass laws on, and everything else falls under the state government or the state legislature. Now, the question was whether state legislatures could regulate the right to abortion or not. Right? There's a plain sort of question there. Now, Roe versus Wade effectively said that they couldn't. Effectively, right? I'm not getting into the sort of details of it. It effectively said that states couldn't regulate, effectively making it sort of legal or not criminal, legal across the United States, right? Which has its own sort of policy consequences, both in people have sort of commented upon the economic considerations that, okay, less crime, and there's this whole freakonomics theory on it, which has got its own sort of arguments, right? Like, once again, I'm not on the question of sort of what should be abortion rights, right? I'm on the question, and this is my understanding of the issue, that should the Supreme Court be able to do that? Or should it be left to the legislatures, whether federal or state, depending on whatever the question of law is? Ultimately, Planned Parenthood further qualified the judgment.
Right.
Planned Parenthood, which is the sort of judgment that came afterwards. And in this regard, I think this is the important factor here, that you see a divergence. There's a part overruling
Right.
in Planned Parenthood. And Based on that, when now Justice Barrett was writing earlier on the question of what are the super precedents, right? Or precedents when we sort of look at, again, for sort of those who are also not students of law, right? There are certain precedents which are sort of, again, the Supreme Court at the part has sort of overruled its precedents. I think that's the case in sort of most countries. At the same time, the American law or American jurisprudence, or specifically the originalist or textualist approach, more originalist than textualist in this regard, has been that, listen, there are certain legal truths that we've established. Right? The certain legal principles which have been established, and we are not going to revise them once again just because we have the power to sort of overrule our own judgments.
Right.
These are what Justice Barrett, again, these are sort of, again, most of Justice Marshall's, I think the classic case of Barrett versus Madison, where the concept of judicial review came about in the context of the American sort of law and policy making. But again, what Justice Barrett wrote was that she said, okay, these all are sort of the super precedents. And it's not like she made a very strong negative comment therein, but she did not include Roe versus Wade in it. Which is also, that argument is further sort of verified by the fact that, listen, the Supreme Court itself has further qualified it. But the requirement for a super precedent is that, well, it's something that does not require qualification. Ultimately, abortion becomes a policy issue, right? Again, wherever people might stand on the issue, the idea is that there's no absolute truth about it. Right? One might say, without getting into the merits of the argument, one might argue that at 8.5 months or 8 4/5 months or 9 months minus 1 day or whatever the exact period is, right? Whatever has been established by medical science, that, listen, this is a full-born baby, right?
Right.
Some people in some schools of thought even advocate that abortion is to be permitted even when the child is out, like this is post-delivery abortion. Right? There's a school of thought that advocates that too. Again, once again, I'm not on the merits of the argument as to what point do you allow abortion and you don't. And I'm not even any of that. But I'm on this question that because you have these distinctions, right? Because there is a scope for determining where you draw the line, it ultimately becomes a policy question on exactly that.
Right.
And it is exactly on that it ceases to be a constitutional right until unless sort of inserted by way of amendment and so on and so forth. Sure, the situation is as it stands at this point. But how would you sort of comment on, one, the question of the legislation part by the Supreme Court, by the judiciary at large, and then again the question of sort of super precedents and fear. Again, while having said all of this, I'm also of the opinion that society has moved, it is, for the lack of a better word, progressed to a point where, from a policy point of view, it's going to be very difficult to sort of go back to a period where sort of abortion, there's a blanket ban on abortions.
Not only a ban,
larger question,
a crime. Pre-Roe and Wade, it was a crime in a lot of states.
Yeah, so that's what I'm saying, right? Ultimately, it's not possible. Again, I'm just looking at the pragmatic policy, society, culture framework. It's not possible that you want to sort of just completely erase it and say, okay, this is a crime, this is a blanket ban on it. I don't think that's going to happen.
Right.
Even with, let's say, 6 so-called conservative judges, which I have my sort of doubts about, which we will also get to. What are your initial comments on, again, the super precedents, the nature of Roe versus Wade, fear amongst alleged, like if at all that fear is tangible and sort of rooted in any sense of reality, and obviously the clash between whether the judiciary should be able to legislate these rights or curtail the rights of the state legislature in, let's say, regulating abortion. In some cases, okay, opinion of 2 doctors, threat to life to mother, in all cases. So there is sort of a large sort of spectrum there. So your comments on these aspects. I'm going to mute myself for a while because I'm trying to get Yash on board as well, right? You can feel free.
Right. So I think what we need to understand about the super precedents is how the US Supreme Court functions compared to our Supreme Court. So their Supreme Court, the Supreme Court of the United States, sits en banc. So all the 9 judges sit together. This means
Yes.
that all the cases are decided by 9 judges, unless some recuse or some are unable to get into the hearing. But all 9 judges, the bench decides the issues. But for our case, we have a hierarchy of benches that can sit to decide cases. Now they are part of stare decisis, but again, the number of bench, the strength of the bench decides the authority of the judgment. And this is something Felix Frankfurter said to B.N. Rao when the constitution was being framed. He said, make your Supreme Court sit en banc, because the law laid down is final for all intents and purposes. But again, that we didn't follow because, frankly, just the numbers were not feasible for Indian litigation even at that point. So that's why they are not so bound by the principle of larger bench and smaller bench. The smaller bench is bound by the decision of the larger bench, right? Unless you got to go to the Dawoodi Bohra judgment route that it has to be referred and so on. They can actually reconsider in a case. It's not as difficult as referring to another bench and then that bench refers to a larger bench, so on and so forth. So, and you're right, exactly, that today, if we say that somehow Roe versus Wade and Planned Parenthood versus Casey, they're not going to disappear, right? We rely on abortion and on these rights too much to just all of a sudden state to come up and say that it's not allowed whatsoever. And for that matter, that's why I said that Roe versus Wade is like the road runner, right? The Republican or the conservative Wile E. Coyote always comes around with the TNT to just get the road runner, but it doesn't ever end up happening. Maybe there are slight variations, but it doesn't get removed from the case law books. For that matter, if we note, there was a judgment called Box versus Planned Parenthood. There, it was a judgment on the circuit level, the Seventh Circuit Court, by Justice Barrett herself, that struck down the Indiana law, that didn't interfere with the district court judgment, that struck down the Indiana law being unconstitutional. And for that matter, on reproductive rights and the dealing with the carcass of the fetus, the bench with Amy Coney Barrett was even harsher than the Supreme Court decision, right? The Supreme Court ended up going lighter on the judgment on the Indiana law. So for that matter, I think that's also something that wasn't highlighted by the Democrats on that side. Perhaps not even so much by the Republicans, because they have a certain issue with affirming that logic.
True. Yeah, I think there's a very valid point that on some level you sort of cast these sort of molds that these sort of political figures or judicial sort of figures are going to fit this particular mold, and that's how sort of it's going. Very valid point coming up there. And obviously, we'd also get in further into other points that have been that we can sort of bring up from some of our opinions in the past. But I'm going to get in Yash now for some initial comments from his side. And Yash, I think you're gonna have to. Can you hear us? I hope the audio is okay. For our viewership, Yash is also just very recently enrolled at the Delhi Bar, and yes, can we?
Am I audible?
Yeah.
Yes, though there's an echo.
I think then if probably one of you mute your mic, then it might help. Yeah.
Yeah, I think we're muting ourselves, so we get in your initial comments.
Yes. particularly wanted to emphasize is upon the appointment process in comparison with India, and it's like comparing two extremes. I was reading like how judges are appointed. Now, of course, my co-panelists are very well worried about the procedure which is written in the Constitution, which is written in the United States Constitution. The knowledge would be that conservative judges in the United States are regarded by a non-statutory body. Quite shocked to learn this. There's a body, there's an organization called the Federal Society, bent on let's say a conservative ideology. And I was quite sort of flabbergasted at what sort of role this society printing judges, specifically the conservative judges in the United States.
Yes. We're having a slight issue with the audio. There's a lag.
Yeah, it might be a lag.
Yash, I think you're mobile right now in a car. I think that's causing the issue.
Wait a minute. Please.
So you can maybe try to sort of. If you can try, let's say, stopping the vehicle, and if that's possible. Okay, we're having some difficulties. Yes, if you could try sort of joining us again, you can try and disconnect and join us again. That'll be. Yes, let's hope that audio sort of gets in there. But like I said, I think a very interesting point that Yash was making, and I was going to get to that at some point myself, is the role of the Federalist Society in appointment of or setting the landscape for conservative judicial interpretation. Right. Again, for our viewers and sort of the larger discussion that we are sort of a part of here, on some level, we're not looking at a political conservative policy platform here, right? That's not what we're discussing. What we're saying is that a conservative judicial philosophy is effectively just that which interprets the law as it is, right? In the sense that it does not lead to an interpretation which is very far away from what the text of the law is, or what the precedent in that regard is. Right? It's not sort of stretching the law to a very sort of wide scope in that regard. Right? So, and that's what sort of Yash was also coming in. We just sort of discussed the difference in terms of judicial philosophy, right? So let's see if we can get Yash in, and maybe if his audio is getting any better.
Am I visible and audible? I hope.
Much better. I think Yash is much better.
All right. Yeah. So I was at the point that the role which a non-statutory body in the United States is playing in the appointment of the judges. Now, it is very well known that Mr. Trump was preparing for his presidential since. So what he came to know in the early stages of his campaign was that this whole appointment procedure to the United States plays a major role in getting you elected to the Supreme Court. So what Mr. Trump did is that he established or tried to establish ties with the Federalist Society and its vice president, which at that time was Mr. Leo Leonard. He is a very well-known, and he is often labeled a conservative American lawyer. He headed the Federalist Society. Now, Mr. Trump had several meetings with Mr. Leo Leonard, and after those meetings, right away, midst of his campaign before getting elected, Mr. Trump gave out a list of the Supreme Court recommendations which he will make. That I have read has played a major role getting hit, and that somehow helped him to get to the presidency. The first nomination which Mr. Trump made was of, I believe Neil Gorsuch. Now, Justice Neil Gorsuch, at age 49, was himself a member of the Federalist. So you see, a non-statutory body over there is advising the president as to should nominate to the Supreme Court, and those judges will be giving out which will have huge constitutional ramifications not only in the United States but even in Commonwealth nations. So let's imagine India. Let's say any right-wing or left-wing organization is the president. Let's say the RSS is advising the president as to whom you should appoint as a judge. Can you fathom? And now let's come to the Indian now. The Indian position is quite the opposite of what happens in the United States. In the States, there's a whole transparent process in which skeletons from the past of a judge's life are heard, and it's almost like meaning. It reduces itself to a mudslinging match. If you have seen confirmation hearings of Justice Neil Gorsuch asking 11 questions as to what kind of drug he used to smoke and why he was rusticated from there. Now what happens in these hearings is nothing but mudslinging competition which goes on. The next the Indian scenario. The Indian scenario is as opaque as you can imagine. The late Mr. Jaitley, who was himself a very fine constitutional lawyer, labeled the judicial appointment procedure as similar to taking a membership in gym. You know how difficult it is to get a membership in Gymkhana in the metropolitan cities, and he said that becoming a judge is equally difficult. So you have no transparency over there. Here you have judges appointing judges. No other jurisdiction follows a method. So these sort of comparisons, and I'll tell you why. I even came across some that said that if we follow a system like US, what happens? I don't think that a system like US can be feasible in Libya, for the very reason that our politicians have turned every platform battle zone. Our politicians fight their channels on the primetime debates. They fight in the courts. They have their anti-defection battles there. They have their defamation suits there. They fight, of course, in the legislature, sometimes even physically. So and let me tell you one thing. Let me bring to your notice one thing. We have these select committees and standing committees in the parliament. These are the only places where these politicians work in harmony. You can imagine Shashi Tharoor and UDP politicians working together on some law. These are the only places. Now just imagine there's some judicial committee, and that committee has to decide upon the appointment of appointment. Now, majority of our parliamentarian record. How can you those parliamentarians who have a tainted record to appoint a judge who might later adjudicate their cases?
Okay. So I think some very valid points being brought up by Yash in this regard, Siddharth. And I'll get you in on this as well. For our viewers here, right? A very interesting question, and Siddharth, we did touch upon this earlier as well, is the question of the comparison to the Indian system. Right. A very important point here, that here you have one extreme end of one, it's completely a political process. Right? You have a Senate confirmation after a presidential nomination. And that there is, in that sense, very, very, it's a very transparent process, for the lack of a better phrase. Right? Everything's out in the open. As opposed to the Indian system, where you have a collegium in place even after the 4 judges case. And you
Right.
also have sort of no sort of senator or no sort of Lok Sabha, Rajya Sabha committees sort of listening to. Obviously, we have a Westminster
Right.
model, so you assume that the union sort of enjoys the support of Parliament and all of that. But you let's assume or let's sort of contemplate the possibility. I would also sort of agree with Yash completely that such a system is not sort of very workable in India. But any comments on that as to how you would
Right.
look at the two aspects that Yash brings in, right? On some level, we're just saying that the conservative judicial philosophy is adherence to the text of the law, adherence to how the law is rather than what it ought to be. And at that same time, Yash brought in this concept of or the role of the Federalist Society. It's not a sort of sure. I wouldn't even sort of look at it as a non-statutory body. It's a non-statutory body that sort of goes without saying. But at the same time, there is
Right.
a role that it plays as a philosophical or ideological sort of backing, which, in my honest opinion, is also something that has not been very strong, right? Ultimately, if they're looking at sort of vetting judges for a very judicially conservative philosophy, we've seen Justice Gorsuch's opinion in the LGBTQ case regarding the employment termination part, right? The discrimination, the interpretation that, okay, sex in effect is to be read as sexual orientation, right? Again, it's not the literal same change as Navteej Singh Johar, but it's effectively, again, for our Indian audience, it's pretty much the same distinction or the same sort of parallel that is being drawn there, right? And they say that this was from a very original
And yet it was
textualist approach that he sort of brought it further. Right, at the same time, you have Justice Roberts, who, whether it was in the original Affordable Care Act case or in other sort of recent litigations before the Supreme Court, has almost always, on specifically the very politically charged issues, even the sort of the DACA, the immigration policy cases, has sided
right.
with the Democrat appointed judges, right? I'm sure he's himself sort of said we're not Bush appointed or Clinton appointed judges, but well, let's say with the more progressive judges who have a more liberal approach to interpreting the law as it is, right? Let's just go with that terminology. So, what do you think the Federalist Society, in that sense, has actually been able to sort of establish that in terms of getting genuinely conservative judges through? Sure, I think it's difficult to say that Justice Thomas, Justice Scalia, or were not from a strong judicial conservative, like sticking to the text philosophy. Justice
Right.
Thomas still is. Right? And that part's there, your comments on the FedSoc part, and certainly whether this is sort of workable in the Indian scenario. My honest opinion is probably not, right? You go back to the NJAC sort of system, and which, in my honest opinion, is something that was the constitutional frame, like in the sense that the president had an active role, or the executive was supposed to have an active role, which is sort of then translated into NJAC. So those aspects, right? Appointment comparison to India, and then obviously the role that the FedSoc plays, and the kind of influence, the alleged influence that it has now achieved. Sure, that also translates into sort of federal judge appointments. But let's look at it from the point of view, let's say, only these Supreme Court appointments that we've seen in the last few years, a couple of decades, if I may.
Right. I mean, to begin with, we read the Federalist 78. That's the one on the judiciary. That's where the idea of the court not having, an army or any kind of force to execute its judgment. That's where the whole principle comes from. And a lot of things that Alexander Hamilton wrote on the judicial organ of the state. Now, prior to that, he wrote in Federalist 76 and 77 the procedure of appointment to the Senate and the executive and the power of the president to appoint his cabinet and so on and so forth. And entering into the 78th Federalist, Hamilton didn't even feel that he needed to lay out anything separate about judicial appointments that he already hadn't covered in Federalist 76 and 77 with regard to Senate and executive appointment. So, to begin with, there's no real distinction between the principles on which justices and judges should be appointed, at least on the federal level, right? it is a political decision. It is done in a political organ of the state. Nomination is done by a political entity on political grounds. It's not so much like us for as in our case, where it's supposed to be the collegium system, or even right from then, that your views, other than some views on your who you were as a person, matter, right? You're supposed to abide by the constitution, be truthful to it, and give justice according to it in the interest of the people of India. I mean, that's perhaps the central tenet of how judicial appointment, judicial work in India has been. But coming to, let's say, the 70s, Justice Bhagwati himself, in a previous judgment, this is prior to the first judge's case, in Himmat Lal Shah's case, which is the emergency time case where, uh, uh, emergency time case where high court judges were transferred without their consent. So, the Supreme Court also talked about the points of view, the views that the judges have. That also has a bearing, because it was also about how a judge is supposed to be appointed, and the views that a judge has. The social context and the social ideology that the judge has. That's also important in judicial appointments, and that's always been a very slight, I think, an underscore to the whole image that a judge should be separate from politics in our context, right? In our context, a judge should not be political at all. But when you talk about the Federalist Society, and let's imagine a Federalist Society here, whenever us Indians, when we look at a Federalist Society kind of concept where you're taken into the wings right from college, right from your undergrad, you're in a Federalist Society that talks about conservatism, or on the opposite end, you're talking about a liberal wing, a similar parallel liberal wing. You're perhaps indoctrinated in a way, right? Like, if you are part of that society for decades, you grow into that society, and afterwards, uh, you are part of the Republican appointments and part of the Republican regime. And if we see Robert Bork, he became the hero of the Federalist Society after he was rejected by the Senate. So that kind of system, I don't see prevailing in India. I mean, there's the scope of abuse, just to think about it. I think it's an entirely different paradigm. Just to even start with that conversation.
Okay. So again, two very sort of valid points being initially brought up by Yash, and then Siddharth, you did catch on that. Again, two minor points that I would sort of bring in in these two regards is one, and very correctly pointed out by Yash, around some level, while everything becomes a political battlefield, right? We've seen that the Indian system of committees and committee hearings, the very recent example of sort of tech company executives just refusing to sort of turn up, is something that still requires much consideration and needs to evolve, right, for it to have some force. And so that part's certainly there. Right? Second thing, again, the American system is largely on the grounds that it's either the Republicans or the Democrats. It's effectively a two-party system. And in that sense, okay, if you don't have the Senate while you're, let's say, the president, you don't have, let's say, the Senate of your party, then it's going to be difficult for you to sort of get that in. But in India, the system is very different. Right? The Senate has exclusive functions. Rajya Sabha clearly is not on the same footing, if I may, as the Senate in the United States. Right? The functions and the power that it has as an organ of state. That's an important consideration in terms of the Indian comparison. And as far as the FedSoc is concerned, ultimately, like I said, right, my opinion on that would be that one, they haven't been able to get strong conservative judges through, not in the recent past, at least. Right? we obviously have to see how they develop further, right? But Justice Roberts' judicial philosophy is, if any, I mean, if that is to be taken in any value, right? Just on the face of it, it would be very difficult to categorize him as a conservative judge, right? And same, like I said, right, the very recent sort of employment termination, discrimination against LGBTQ people. There's a very similar sort of line that's taken in the very recent judgment, where I think the only dissents came from, I think, Justice Thomas. I think it was 7-2. Right? That's what the vote of the Supreme Court was. So I would go to the extent saying that the Fed Circuit itself has not been able to sort of really get sort of, if at all we go by a vetting process, if at all I were to sort of use that phrase, for the lack of a better one, I don't think they've been successful, at least to this point. Most certainly, I think the system in India is sort of nowhere close to sort of happening, right? Because again, the system is entirely sort of judicially driven, but there's sort of other considerations, right? Ultimately, and this is my whole point regarding like what I call judicial conservatives, is that their job is supposed to stick to the law, right? Now, this came up a lot in the hearing system, right? And I'm going to get both of you in on the hearings as to what happened. So that will get you in on first here. Then ultimately, the job of a judge, again, I'm going old, right? I'm going sort of back in the old common law. What's the job of a judge? It's to decide a dispute between two parties, right? The dispute between two parties, right? To go Lord Denning, I think it's Lord Atkin, is that the job of a court is not a discipline. The job of a court is to decide the question in controversy. Plain and simple, right? There's a question of law before you, and you answer that. And a conservative judicial philosophy would suggest that you answer it based on how the law already is, what the law is, as written, as already established, rather than how the law ought to be according to you. Right. Now that's the sort of point regarding the next point that I want to get both of you in on. That ultimately that's the clash between the Republicans and the Democrats. And my understanding of the Senate hearings. Let's get to the Senate hearings now, and I think we'll also get in questions from the audience if there are any. Please feel to sort of send in your questions. My initial thoughts regarding the committee hearings was that this is not a judiciary side committee. That this is probably a healthcare committee that the Senate has, right? Because there's not a single question on the law from the side, at least of the Democrats, right? Even for the Republicans, for that matter, who focus on our family, sort of values, trying to counter the Democrats on the completely other side. I didn't see much law coming from shore. You had some considerations here and there. But ultimately, like at least on the Democrat side, it was entirely sort of driven by these many number of people are going to lose their health care or benefits of insurance. And ultimately, it was about how, again, for our viewers here, there's some pending litigation before the Supreme Court. Currently, the case is itself called California versus Texas, which is symbolic in its own sense. The two largest states for the two sort of the largest red state and the largest blue state. And ultimately, the clash is about, now there are certain provisions of the Affordable Care Act. Right? This is the new law that was brought in during the Obama years, often referred to colloquially as the Obama Care. Right? And here, ultimately, again, to put it really, really short, there's a lot more to it, but ultimately, it's a question of the interpretation of the Commerce Clause. So the Senate, Siddharth, you can sort of come in first in this. The Commerce Clause is something that tells you what all the federal legislatures can legislate on. Right? And just giving a background for viewers here, that ultimately it was decided that, okay, in the initial question, the constitutionality was challenged. The court said that Justice Roberts, being with majority, siding with the judges, the more progressive liberal judges, or at least the Democratic Party judges, that okay, this falls within the ambit of interstate commerce. That is, you are supposed to buy insurance, you as a citizen, as an individual, can buy. You're supposed to buy insurance which is sort of regulated or mandated or authorized so by the state. Right. This is, again, I'm putting it really, really short here just to give a background. You can come in on this, you can fill us on the policy and the law of it. Ultimately, there were some certain changes brought in by the current administration in terms of the policy, in terms of the law. And the question before the court in California versus Texas is after a certain sort of amendment of a certain part, are certain other aspects completely sort of done away with? Right. That, for example, if I amend a certain part of this particular act, are these other provisions also completely done away with as a result of this amendment? So do they stay or do they not? Right. So that's the current litigation. So, and that's apparently what the fight became all about, at least for the Democrats. And these many people are going to lose their healthcare insurance. Again, from a sort of economic standpoint, my understanding was that it was restricting the free market, and my limited understanding of this is that it shot up insurance premiums for most people in the United States, effectively making healthcare insurance far, far, far more expensive for Americans. Right. And that was the sort of immediate sort of economic effect. Even for those who sort of could or couldn't sort of, who could afford it sort of privately otherwise. So that's the key question here. So it became policy issue. It became a policy issue that Judge Barrett's going to sort of strike down when I think it's going to be heard in the 10th of November, I believe. And that she's going to strike it down. And ultimately, the political sort of fight just became about preserving a healthcare a couple of weeks before election time. And that's, is that the way, or should that be a consideration for why judges should be appointed?
I mean, yeah, it goes back to the fact that you're asking a judge knowing full well just to get that snippet of an answer or a non-answer. You're just asking a judge. They can't disclose their judicial opinion. Even as a sitting judge, they can't, right? So you're asking that question that's perhaps in some ways moot. Now, Amy Barrett did write an article saying that John Roberts extended himself in interpreting the individual mandate under the Affordable Care Act, which is basically that every American must get health care insurance, and that goes into the common pool of insured people. So if it's a common pool, it essentially becomes a factor of insuring that pool rather than individual members who can be charged higher for any pre-existing conditions or any abnormalities in their make, so to speak. So that individual mandate was very important to create a common pool, and if you didn't subscribe, then you were penalized. On the basis of this logic, this was taken as a taxing statute. This was taken as a taxing clause, an exercise of it. So now in 2017, the Senate removed the charge that was, on default if on individual mandate, if you didn't get insurance, then your penalty was 0. Now the issue became, if there is, 0 charge for you not getting insurance, now the price is going to shoot up, right? It's going to, I wouldn't say come back to the previous level, but certainly it's going to be an immediate shot up because the common pool principle is gone in effect without it actually being, removed. So the issue becomes whether, that based on the, just removal of the common pool principle, does the law become unconstitutional? Does it become, against the Constitution, since it's, the core has been removed? And now I think the main issue becomes, does Amy Barrett have any, any preconditions or any prejudgment to this? And remember, she even said that maybe there can be a question of her recusal as well. If, an application to this effect is made, then that can also be considered. But certainly, I think that shouldn't be just the question. And I was looking at Cory Booker again and again, just trying to get an answer out of her. Do you care about these people? Am I supposed to say, no, I don't care about these people?
Yes.
What is she supposed to say?
Yes. Yes.
But
No, absolutely. Yeah.
so that I see perhaps as one of those things where you can neither win, you can't lose. You just gotta go through it. And one thing you can be damn sure about in the US context is they're going to stick to their procedure. The Democratic line and the Republican line is drawn complete, separates the earth. There's no question of almost in most cases crossing to the other side. If this is the process, they're going to stick to the process. If you have if it's a democratic senate, the appointment of a uh, conservative judge is going to be difficult. That's a known fact. And I don't, at the end of the day, believe that any system is perfect, right? It's just how you stick with it and how you execute it. But they have a certain kind of mutually self-assured destruction kind of uh, consistency to it that you just see over like 300 years. That's how like 3 centuries of politics has evolved.
Yes, I think that's a very, very important aspect that you bring up. Is that there is a certain tradition that is followed and it sort of has continued to be followed. But a very interesting thing that's coming up, and I want to make this sort of, I want to sort of draw in the other political considerations here, right? That ultimately it's a political process, like you said, right? It's a political procedure, and you need to have both the Senate and the president to sort of get a vacancy. The first requirement is there's a vacancy to send a judge to the Supreme Court. At times there have been cases such as Justice the appointment, I think, by President Eisenhower, who appointed a Democrat judge who sort of ushered into this sort of series of opinions, which is sort of very, very liberal. And I think, maybe perhaps you've seen this once or twice, where you've seen, okay, maybe there was a Senate, the Senate was just controlled by the other party. Certainly not election years, and certainly not.
Certainly not now.
Yeah. Again, that's the point. Perhaps the divide is something that has become so more recently, like I said, right? Post Ginsburg, post Scalia, because they still had very comfortable modes, like 97, 96 was for both of them as they got confirmed, right? Politics, as in if you look at sort of Pew Research numbers and other numbers, the politics, the divide between the average Republican and average Democrat has gone really, it's increased quite a lot. Right. So that part is absolutely there as well. But what I want to get on is this question, and because we're on this sort of politics debate, is the question of court packing.
Right.
So there have been sort of suggestions, there have been recommendations. Joe Biden is still to comment on that. But there have been recommendations, okay, we can look at so the Democrats are sort of suggesting that there will be a change in the political appointment process for judges, and there will be a limited term for judges, because it was thought of as with a certain time frame, a certain sort of life expectancy in mind. And that has changed quite a lot in the last sort of 240 odd years. Now, the question is that even if that is to happen, right, let's assume that you can sort of decide on the merits of that. Ultimately, it will require a constitutional amendment.
Right.
It's not like you can pass a bill in Congress and say, even if, let's assume Biden gets the presidency, let's assume sort of they get both houses of Democrats get both houses of Congress. Even still, it's not possible without the entire process of the constitutional amendments in the United States, which involves the states and a considerable number in sort of both the states as well as in the Congress, to be able to pass such legislation, because you're effectively sort of changing that element. So,
right.
And I think this is pretty much been the same way, like I said, for the last about 2 odd decades, right? Slightly less perhaps when it was extended to 9, but since then it's remained pretty much the same, right? And that's what I think one of the senators did mention, that we see it as a political issue, but on some level this is supposed to be a civic issue. Right? It's not a political,
Right.
it's a civics. Right? This reminded me of the fact that our very initial training in terms of what's called social studies. I refrained from sort of calling it a science in that regard. But before that, like an element of that was civics.
Right.
A very basic introduction to fundamental rights. Constitutional remedies is also a fundamental right, 32. We're talking about very basics of civics in that regard. And that's where some of this falls, right? If I were to, let's say, draw from Madison versus Madbury, like, there are certain questions which shouldn't be left open to votes of majority.
Yeah.
Right? Certain questions, that's the important part. Not every
It will
question
depend
is
against
supposed to be
majority
something
as
that
well.
courts decide. Right?
Right.
Yeah, you were saying.
No, I'm saying the whole idea of protecting against majoritarianism, I think, nowhere more relevant than now.
Yes, but at the same time, my point is that only a very limited number of questions are not to be within that domain.
Mm-hmm.
Right? That's what I'm sort of getting to. But yes,
Right.
Any comments in this regard that of sort of court packing? Biden sort of refuses to come in until the 3rd of November. I think it's even not going to be possible for him to be able to do it. Even sort of post. Sure, perhaps if the Democrats get both houses of Congress and get the presidency, then they can look at, let's say, an amendment to the Judiciary Act itself.
Right.
Not to the fact that you change the entire appointment process, which is, I think, quite unlikely, never going to happen, or not without
Right.
sort of significant sort of upheavals. But they can perhaps increase the size of the court,
Right.
and that's going to sort of change. Ultimately, that tells you that ultimately this is not a civics question. Ultimately, that it's not about the law, and ultimately it's about sort of a political side, which, if dominant, is going to. This is being about sort of bad losers, if I may sort of take it a stretch that might hurt. Do you think that's how you would describe it?
I think it becomes a issue of who's gonna just be altruistic for that one moment, right? If we when we discuss this, the idea of giving your Supreme Court justices senior status, of course, so a bill is being proposed in the Senate that aims to limit your judicial tenure at the Supreme Court to 18 years, and Chief Justice Roberts was a proponent of this idea, and he capped it at 15 years. After which, since you have a promise of an office for life, you'll just go and serve the circuit courts for life. And that somehow, I don't know how that's a technicality exception to it. And yes, you're right, it's going to have to be an amendment. But I guess that solves all your issues, a lot of your issues of, the, kill or be killed kind of appointments. Because end of the day, if Amy Barrett is 40, I think 48, her staying on for the next 30 years, and as Clarence Thomas says, that Democrats had annoyed me for 43 years. Now I'm going to be on the bench for 43 years and get back at them. So those kinds of situations, I don't think make any sense in that kind of
without getting into sort of questions of vengeance. And I think both for Justice Barrett and for Justice Thomas, like, without again sort of attributing anything specifically, and perhaps just looking at it from a humorous point of view. If you want to look at it this way, right, that on some level, the American judiciary, right, is not. Sure, it's different from India in the sense that it's not entirely integrated. But at the same time, like, once the Supreme Court lays down the law, that is something that's applicable throughout.
Right.
A good chunk of the law, as a result of the Supreme Court taking very few cases, is set by the federal or by the circuit benches.
Right.
At times, you see strong divergence across 2-3 different circuits. That's also quite prevalent.
Right.
But ultimately, it's not going to sort of solve the system that post that Supreme Court retirement will go back to. Like, it's effectively saying that once a Supreme Court judge retires in India, they go back to the High Court they came from.
Right.
It's not the exact same squarely fitting situation, but it's quite similar in that regard.
Right.
So I don't think that's going to happen either. And like I said, I think the constitutional amendment of this is quite unlikely. Ultimately, what is often forgotten, and these are 2 points that I'd like you to sort of also come in on, what's forgotten for very long, and there's sort of 3 points that I want to bring in here. One is that for a very long period, the Supreme Court was overwhelmingly Democrat.
Right.
Or comprised of judges who were appointed by Democrat presidents. Is the 50s, 60s, the entire duration up until sort of 70s, 80s, when you had Reagan and Nixon coming in, when Jimmy Carter didn't get an appointment, and so on and so forth. You said Bush and others coming in. Since then, pretty much every president has appointed 2 judges, and even though it's been sort of moderate in the sense that it's 4 or 5, so on and so forth, generally has been favoring the Democrats for a long time. Another aspect here is not on the Republican-Democrat question, but on the conservative-liberal question. Even those judges appointed by Republican presidents have ultimately sided with the Democrats more often than not. Right? Whether it's Justice Roberts, who's in so many of these, let's say the DACA issue, the LGBTQ issue, the Affordable Care Act issue. Right? So it still wouldn't be fair when people say, oh, there's a 6-3 majority that is cemented for years and decades to come. A conservative majority. I think that's an unfair point to make. I still think that even after Justice Barrett, even if you were to sort of make this sort of great leap that she's a damn conservative judge, even then, I think this balance is still maintained.
Right.
Talking about these things from a purely ideological, politically motivated aspect, which I don't think it is, right? But even taking the argument to the extreme, that's still not the case, right? We've seen the recent judgments by the Supreme Court, by even the sort of the Donald Trump appointed judges, right? I know, as Justice Roberts said, we are not ex-president appointed judges or vice president appointed judges, which is judges of the Supreme Court, but on some level, the idea here is reflected. The point that he's making is reflected in the judgments itself. And on this end, like, this is the sort of the second part. But the other part I want to bring in on this is that Justice, and I want you to sort of come in on this as well, that Justice Barrett's record as a circuit judge, sure, she's taken up a textualist approach. She's taken an approach which is, people might say, even politically conservative. Let's just give them that side of the argument as well, which I don't agree with. I would say that, okay, she's a judicial conservative, so sticks to the originalist textualist approach. But at the same time, where the law has been that, okay, there are protections of certain fundamental rights or any legal right, whether it's the Fourth Amendment, for example.
Right.
Now, for our audience, this is pertaining to sort of the powers of the police or sort of armed forces, or again, the state intervention in terms of personal liberties, right? Whether sort of police can search warrant and so on and so forth. Right. So in that regard, I think there's this case where at the circuit bench, like, if you're aware, maybe you can come in on that. Is that where she said, listen, nothing doing, this police officer lied to sort of get this conviction. It has to be overturned, action against police, so on and so forth.
Right, on a technicality completely.
Yes. So again, the idea is that benefit goes to the individual. Like, you see this as a liberal or progressive approach. It's not because the judge is liberal or conservative. It's because the law is the way it is.
Right.
Similarly, in the context of, you can come in on the Purdue judgment as well, right? I think that's also something that's quite important. But at the same time, even cases against corporations. Now, this whole sort of really in my opinion, quite an outrageous sort of opinion that sort of Democrats are against corporations and Republicans are for corporations and against individual people. I think it's sort of far-fetched, incorrect, to be very honest. It's quite a caricaturist view, if I may. But again, you've had judgments from our side where she's decided against corporations in favor of some individual plaintiffs and so on and so forth. So, what does that tell us? That ultimately is the question of the law, right? Ultimately, if you sort of look at the right places, again, I think as you began earlier as well, even on the question of sort of is the Philadelphia judgment. I'm forgetting the name of the judgment that you mentioned. She was harsher than the Supreme Court itself.
Yeah, Box versus Planned Parenthood. Yeah.
Yes, exactly. So on that level, I think there can also be an argument that can be made that, listen, she's a very progressive, a very liberal judge, right? Not in the context of the legal interpretation, but in
Right.
terms of the law. What the law is, if the law is liberal or progressive, the judge is going to say, listen, these are your rights.
Right.
Right. So, any comments on that, on our past judgments and how we sort of view that? Whether you want to comment on the Purdue case, you can give a brief background of that, or any other sort of past precedents or past opinions by Justice Barrett during her tenure as the circuit judge.
I mean, you're right in that I think the facts of the case and all these dictate the judgment. But I think the political leanings definitely have a role to play. And I think that can't be ignored in that system. If you look at just the political leanings of Amy Barrett, they're usually they are on a conservative side, pro-business side. That's definitely been the case. And I was looking at the Scottish blog. They compiled the data, relating to her judgments and so on. And I saw that she was pro-business in 9:1 of a ratio. Let's explain the 9:1. In that, if it was a business, and on the other side there was something like a labor union and so on, and a small entity, she would side with the bigger business, and which is very reminiscent of the conservative pro-business idea. It's not completely going away from it. But on the same lines, in the Doe versus Purdue University judgment, she went with a very fair assessment of the due process clause, and to to the point of a rights approach, she said, and I'll explain the facts in brief here. This was a sexual harassment case that was after the Obama Joe Biden reforms in university level dealing with sexual harassment cases and complaints, that the due process was really uh, removed from the in-house hearings, and the evidence that would be taken, and the kind of rights that the accused would have in these hearings.
Yes.
Now, those really violated the due process clause. And when this happened in Purdue University with John Doe, now he's been pseudonymized here, but John Doe had a similar allegation, and he was removed from the university for some sexual misconduct without getting proper hearing, without getting the due process rights that he was guaranteed under the constitution. And she basically said that an approach to protect the rights of the woman, right, if it comes at a blanket prejudice against the man, would be doing a disservice to the equal protection law in the first place. Right? You can't start at a place of punching down. Right? You have to, if you want to create a better and swift procedure for dealing with sexual misconduct cases, you have to start with fixing the little problems that there are, not trample the other side completely. So this was a very important rights-based approach we took, but it would maybe fall on the conservative lines. And similarly, again, in Planned Parenthood, which went to the Supreme Court, she followed Roe versus Wade. As you said, Supreme Court judgments, once they're made through stare decisis, the lower courts follow them. So if you look at it from this perspective, she accepted Roe versus Wade, though she said that it's not a super precedent in her academic literature. She wrote that. But if you look at it from this perspective, your super presidents are what? Your
Yes.
versus Ferguson, your Brown versus Board of Education, your uh, Marbury
Yes.
versus Madison of the world. So if they are heavily contested, it's not a matter of moral implication being put forth on the case that it's good or bad. It's simply that it's how contested and hot button it is. If it's heavily
Yes.
contested even till date, it won't be wholly accepted, and it doesn't say that it's wrong. Again, and that's what we clarified in our hearings. It
Yes.
doesn't mean it's wrong. But if you want to, if you have to be technical, right? You can't just operate in generalities in the law. I mean, everyone's jobs would be much easier and lives would be like hell. So again, you have to be technical there, which is, I think,
Absolutely.
something we have to accept. But yes, I
Absolutely.
think conservatism and her ideology throughout, her career uh, as a textualist, and especially working under Antonin Scalia as a clerk uh, previously, I think that definitely has a role to play in her overall judicial career. We'll see how much it does so.
Yeah. Yeah. So again, this came up a lot of times during the hearings that they kept on saying that this is not Justice Scalia. This is not Justice Scalia. It's going to be Justice Barrett. That's what we're going to
Right.
get, and which is sort of quite right in that regard. Right? On some level, it's a different person. That's the first consideration.
Right.
Just because you've been a law clerk with a, and she said this, I think, during the hearings that um, on some level, she's even disagreed with Justice Scalia on a lot of questions.
Right.
And that will always be there. That will
Right.
always be there. I think there were examples that came up during the hearings there. But before we sort of bring this to a close, right, I want to also sort of get into one particular element, which on some level is also joining Justice Scalia, Justice Thomas even, but was brought up at the time of the circuit bench confirmation or her nomination to the circuit bench. That's when it was brought up by then ranking member for the Judiciary Committee, also now still ranking member, where she said that when the comments were made regarding her adherence to her religious beliefs, and the discussion was that she would not be able to interpret the law clearly because she would be driven by religious dogma. And the specific phrase used by the ranking member is the senior most person from the opposition party or the minority party, which in this case was a Democrat, who said that the dogma is strong in you. Right. Now, the American Constitution, literally the text of the American Constitution says that there shall be no religious tests for holding any public office
Right.
in the United States. Right. Because ultimately, one of the strongest sort of factors, the founding of the American Republic was religious freedom.
Right.
You also sort of get that through the First Amendment and all. But this part still being there, now she comes from what in the context of the American system is a minority, right, in terms of American demographic. She's a Catholic, much like Justice Scalia and Justice Thomas. But this question is only posed to her. Right. Sure, I think it's sort of brought up in earlier contexts as well, but it's never a hindrance. Perhaps it's just that there's a polarization of sort of politics. But this question of sort of religion coming in clash with the law, or at least that sort of argument or that allegation being levied on her, right? Would you want to make any comments regarding that, either through her sort of judicial opinions or otherwise, or perhaps you could draw from the hearings as to the specific allegation by some within the Democratic wing that, listen, she's going to turn out to be a religious extremist. And this is something that came from multiple sort of media sources and sort of commentators and politicians and other elected officials as well. That, listen, it's she's going to be an extremist who's going to destroy sort of this liberal set of values against healthcare, out to get you. In fact, for that matter, I think these questions were brought up very significantly by Senator Harris, who's in the running for the vice presidency now, who sort of brought these up quite a few times. So, any comments on that? Because I found that, like, specifically quite, I don't want to use these sort of loose words such as racist and sort of sexist, which are used with much sort of, without sort of giving them the weightage that they're supposed to be. But on some level, what does this signify? I think it's just very shoddy politics on some level. But how would you sort of categorize this? Or what would your comments be?
To begin with, this was in the context of a paper that she wrote, or a lecture perhaps, where she said that Catholic judges might think about recusing themselves from trials or from sentencing where they are where there's a death penalty involved. If there's a death penalty case, say in appeal or in trial, then they might think of recusing themselves because their faith might not allow them to be impartial. And this, again, was a very important point, that she was part of this paper, but it was written in association with a professor of hers when she was in third year of law school. And she completely copped to it. She said that I wrote it, but I was in the third year of law school and I was a co-author with my professor. So, and I mean, she does believe that your religion should not stand in the way of your ability to render justice. I think that's the first and the foremost thing that we have to accept. Do we say that there's no qualification to it, that someone's going to be a completely impartial without any inferences and implications from their religion or their belief system? I don't think it's plausible or even something that needs to be thought about. I think there's enough standards that a lot of good justices have set in the past when dealing with cases, that you have to stand for your post before sticking only to your religious affiliations.
Yeah,
I think that was something that she handled pretty well, and end of the day, it came from somewhere. That's why I didn't follow the question too much in the beginning. That she did write a paper that said that.
Yes. So yes, absolutely. I think, but at the same time, right? Like this question came up a lot of times during the hearings. That, okay, if it's going to be an electoral question, will you recuse? If it's going to be something that involves Trump or vote counting or mail-in ballots, and again, I think she's been sort of more than Judge Barrett has been more than, if I were to use the phrase, more than forgiving and quite sort of tolerant of these sort of remarks, and said that, listen, wherever there is a need for me to consider recusal, it will be considered.
Right.
But again, this is not something that's been brought up earlier, and we haven't sort of seen this a lot of times with earlier appointments. Perhaps it's election year, perhaps it's too damn close to a presidential election. Perhaps that is a consideration, no doubt. Ultimately,
also, this went hand in hand. If I may just add, this went hand in hand with the questions that have you made any pre-commitments to the Trump administration to decide cases a certain way? I mean, Trump has said that my justices will do away with the American Health Care Act and Roe vs. Wade and this, that. Let's keep that aside. But the question was, do you have any pre-commitment to the administration with regard to how you're going to do justice? While at the same time saying that, do you have any pre-commitment on deciding, Do you pre-commit to us that you will not decide postal ballots issue? Do you pre-commit to us that you won't do this? And Trump's favorite news source, Babylon B.
Again, for our viewers, it's a satire website. Yeah, please.
Yeah, so it's a satire website that shows very compelling, and almost if you might be fooled into thinking that these are real articles. I mean, in the current climate, and it said that Democrats want to know whether Amy Coney Barrett will commit to not decide any cases related to the Constitution. And it's almost, I mean, the questions that were going on, by Klobuchar and some of the Democratic senators. I was thinking, you are against pre-commitment, but you're asking for pre-commitment. So that's a irony.
I think absolutely, and that's absolutely on point. You're hitting the nail on the head. That you're saying, okay, is this what you've done with Trump? Oh, you haven't. Oh, wait, why aren't you doing this for? I think it was primarily sort of healthcare, right? On almost all levels, it was healthcare.
Right.
Then certainly, I think most of everything else was ultimately missing in the discussions that followed during the hearings. Nonetheless, I think if you were to sort of bring this down to one particular aspect, it's ultimately going down to their sort of judicial philosophy, right? If you're remembering Justice Scalia and what he writes in Reading Law, how do you interpret law, right? Ultimately, the idea of the law is that it is what it is, right? And at the same time, that the judiciary is not supposed to make the law. It's supposed to interpret it. And within the law, when there are conflicts, within the law, when there is a clash, that's where the judiciary's role comes in to decide the controversy in question. Some very interesting cases very recently happened in the Supreme Court. I think Google versus Oracle on the question of copyrightability of API softwares. It's a very, very interesting case. And at some point, we hope that we'll sort of bring it to you. Perhaps we can wait till the judgment comes out. At the same time, again, it was by 8 judges, right? It was 8 judges who did hear that matter. But we have other interesting matters sort of coming up before the Supreme Court. Any sort of comments in that direction, Siddharth? Any specific case that you want to solve? We've discussed California versus Texas and the constitutionality of what remains of the Affordable Care Act. But any other cases which are sort of pending before the Supreme Court that you would like to bring up and like to sort of comment on specifically? Okay, this is how the impact is going to be. The Democrats' fear is going to turn into this sort of reality out of some random fiction novel and around those lines.
I think to your point that, as you said, that the role of judges and justices should be to interpret the law, maybe not legislate. But I think there's, I would differ with that to an extent. That let's say how this system works out. Let's say I think the American system is far more textualist and original than let's say our courts, right? And I'm not saying that's good or bad. I'm saying that's just a thing. I think over the centuries, I think a more textualist and a more rigorous approach to being committing to the word of the law has existed there. But the issue is that kind of commitment to the word of law requires a lot of factors. Okay, a lot of factors to exist. To be successful, in a very fast-paced. So this means that politically,
for example, antitrust law.
Right. Yeah, exactly. But exactly. I mean, very few things that are maybe the markets and the commodity trading maybe, but perhaps there's nothing more fast moving at this point. But even in normal cases, you would need a certain kind of fluidity in your legislations in order to be able to make changes as soon as the need arises, right? Or as on reasonable time. So like without that being the case, let's say you have a 2-party somehow deadlocks in your legislature, then you can't expect a court to stick with the founder's status of 1789, that this was exactly how it was in 1789, so we must at all costs stick by it. I'm not saying just deviate completely away from it. That's maybe the wrong direction to go, but I'm more on the point that if you take the California versus Texas illustration, the kind of stances that have been taken here on the after the 2017 amendment that put the penalty or the tax penalty of not getting insurance to $0, effectively removing the individual mandate. After that, what ended up happening is that this was challenged by Texas and other Republican states, saying that okay, now that individual mandate has gone, they didn't repeal it. They didn't repeal the act. They removed a part of it, altered it to zero. Right. This can start into a basic structure argument if it reaches certain levels. But turns it into zero. It turns the amount into zero, which is basically about the core of the law. And then the states go to the court, and these are Republican states, by the way, that say, okay, only interpret the law and nothing else. Textualist, right? Very conservative. Texas and a few other states go ahead and say, okay, the individual mandate is essentially scrapped. Now, let's do away with this law. It's unconstitutional. Trial court says, okay, it's unconstitutional. The individual mandate is gone. Then again, and the federal government takes a stance that, okay, we side with the states. Now, in appeal, California has to come. California has to come and say that no individual, even without individual mandate, now this law is still alive. Now, this is the problem with being textualist. Like you can't be only textualist in court and have a kill or be killed attitude in the legislature. I mean, in all your other branches of government, you're just fighting tooth and nail about just about everything, and you say that no, stick by the law. Stick by the law that was passed. That's a tough proposition for you.
That's a very, very valid point that you've gotten to. That reminds me of Justice Scalia's reading law, right?
Right.
I think it was probably the last book that he'd written, and it was about statutory interpretation, and he dealt with this question. It's sort of, for those of you who haven't read it or haven't sort of got your hands on a copy, like there are multiple interviews and discussions available where he sort of comments on it. And I think a key element that he does talk about it in, I think, one of the interviews with the FedSoc, and it was organized by the FedSoc at least. He says that, listen, our point is not to sort of be textualist about something that didn't exist back in the day.
Right.
And you can say, okay, so obviously the founding fathers or the initial Congress members could not have sort of thought of the internet, for example.
Right.
So you can't say that the freedom of speech and expression is restricted on the internet. But
right.
At that point of time, they did think of things that were around them, including, let's say, sodomy or abortion or other elements. Elements within society which were in front of them. So that's the point. And he says this. I think you're absolutely on point here. And I think within the book, he sort of comes up with various examples to sort of touch upon this as well, including his judgments, right, in that matter. Is that you can only be textualist where there is scope for being textualist.
Right.
The idea isn't that, okay, if by that logic, everything should go back to the Bible. Right, or perhaps sort of text that sort of the Old Testament, if I may.
Right.
So, in that regard, again, I think drawing from a very recent sort of post that Professor Taleb had put up on religious doctrine, not religious doctrine, on sort of violence and culture and all of that. Says, see, ultimately, someone who's following, let's say, a far bit of sort of Salafite Islam. Sort of what we see, sort of modern Iranian area, and someone who's, let's say, a sect of Protestant or Christian sects within the Protestant branch and sort of further going down into the denominations prevalent in the United States are far closer to each other than most people around. Right? In terms of pure doctrine, pure text.
Right.
And sort of that gets you to the point, right? Okay, are you going to sort of place it back that way? No, where there is no scope for textual interpretation, textualist interpretation, it cannot be gone. It's not a question of whether it should be, it cannot be. And I think it's a very, very valid point that you do make. Certainly in terms of sort of pending litigation, like I think we've sort of always come back on California versus Texas. I think sort of remains to be seen. I think also, again, this question will ultimately go back on sort of judicial interpretation. For example, if we go back to NJAC, see, on some level, we come to NJAC in a different way, not in the administrative side, but on the sort of judicial side, in fact, where they say, listen, we're going to strike down 124A. We're not striking down anything else.
Yeah.
Because you don't need to.
With the striking down.
Yeah, right. So, on that, sure, perhaps I'm not saying that that example there squarely fits the Affordable Care Act, but that is one way of sort of looking at it, or interpretation, right? I'm not getting into the specific text here. I think we're sort of close to about 2 hours, and I think we're sort of getting back in terms of the lag that we're sort of getting for sort of tonight. So our sincerest apologies to our audience regarding at least the lag. We sort of make attempts to sort of rectify this. Thank you so much, Siddharth, for joining us.
Thank you so much.
It's been quite an interesting conversation. And it is our intention, this is for our viewers, we hope to get Siddharth on back soon. At the same time, we'll be getting in other panelists as well to discuss sort of prevalent issues, both law as well as sort of politics in the United States as well. We have the elections coming up. We have very recently the DOJ deciding to file the antitrust case against Google Inc. So that's going to be quite interesting, and specifically on the areas, let's say, of IPR and competition law that we focus on quite a lot. We'll be looking at the economic angles of such cases as well. So we plan to discuss all of these as well. So please do write to us with suggestions and recommendations regarding these cases and other aspects that you would like us to consider and discuss and comment upon in the podcast discussions that we plan to have in the coming weeks. Thank you so much, Siddharth, once again for joining. It was quite a pleasure for us.
Great.
And thank you so much to our audience for sticking with us for all this while. And once again, we'll make an attempt to get this audio video problem sorted out. Right. Thank you so much, everyone. Stay safe. Take care of yourselves. Good night.
Good night.